Hi, Sylvia.
Is a microphone?
Yeah. Tape before this. Oh. Tape all on me. How's the roads, Jamie?
As clear,
Clear and dry, huh?
clear and dry.
Good.
Okay.
Okay, are we ready?
We are ready?
Okay. We're ready to start our meeting. Trent, you want to say opening prayer? No, I'm just kidding. Okay, all right, that's good enough. Okay, is this our presenter here?
This is Ryan, yes.
Okay, Ryan, take it away.
This is Ryan from the Office of Property Rights.
Richard.
Oh, Richard, sorry. Office of the Property Rights Ombudsman, the office. They, this department of, it's within the Department of Commerce. They go out and train on land use everywhere throughout the state. And so we're fortunate that Richard was willing to come down, especially I think we started this dialogue 2 weeks ago about trying to get somebody down here to train you. Today in commission meeting, you will have land use decisions that you will be making. And so I felt that it was super important with 2 new commissioners to get you trained first before you at least make those decisions so that we have everything nice and tidied up in a bow. But Richard, we'll turn it to you. You should be able to run that mouse right there and take it away.
All right, perfect. So again, my name is Richard Plenn. I'm an attorney with the Office of the Property Rights Ombudsman. Just to kind of give you a little bit about what our office is and what we do. So we're an independent state agency. We're housed within the Department of Commerce, but we have several roles. But really, we're kind of a statewide resource for both government officials as well as private citizens about the law on eminent domain and takings and land use law. So the 2 big functions that we do is on the taking side, whenever the government needs to use eminent domain and needs to acquire property and there's a dispute about what they need to pay the property owner, we can mediate those disputes, and so we help the parties come to an agreement so they don't need to go to litigation. And then on the land use side, if there is a dispute about a particular application, our office is available to write an advisory opinion where we try to preview what a court would say if the parties were to litigate as another attempt to help keep parties out of court. And so so that service, we generally answer land use questions from anyone. So government officials, citizens are welcome to call us. And then we also provide land use trainings as well as part of this function. And so our office is small. It's staffed by 3 attorneys, and then we actually just added a new position to our office who's the statewide land use training coordinator. And so his name's Rob Terry, and he's a professional planner by trade. And so going forward, he'll kind of be the one in charge of kind of coordinating all these training efforts and getting all the available resources that are out there in the state to those that need to get the training. So we're excited he's just getting up and running. He just started this last month, so we're excited to have him. But so today we'll go over basic land use subjects, and I'm happy to kind of to get through the slides and then answer any questions you may have and have a discussion. So let's see. Oops. Gotta remember where I'm at. All right. So this is probably small for everyone to see, but I just have a kind of a screenshot of our website. So part of what we do as far as getting information out to the government and to the public is we maintain a website where we summarize various legal topics about land use and takings, and we summarize recent court opinions that have come out, as well as we publish the advisory opinions that we issue in every dispute. And so the website you can refer to get a lot of questions answered as well, and that's just propertyrights.utah.gov. So you're welcome to check that out and see if that answers some of your questions. But kind of starting out with the basics, getting down to where do we get this authority of the government to kind of regulate land, and what is the extent and what are the rules, right? I'm sure everyone's kind of heard from some property owner at some point in time, something to the effect of, I can do what I want with my property. I thought this was America. To me, that's just kind of the version of the grown-up version of, when we were all kids, we heard it's a free country, right? So what can the government do, and what can't they do as far as passing regulations, and how are they supposed to go about doing that? And honestly, so the Constitution doesn't expressly mention property in a lot of instances, and part of that is because the idea of property rights was so ingrained into the founding fathers in that culture when the Constitution was written, that there didn't have to be a lot to be said, right? And so, but what the Constitution does say, there's two instances where it talks about property specifically, and one is the Due Process Clause, which is found in both the 15th and 14th Amendments, and in both cases it's basically word for word, but it says that no person shall be deprived of life, liberty, or property without due process of law. And so due process can be either substantive due process or procedural due process. And so the difference between that is substantive due process is, getting at whether a law is so unfounded or is so arbitrary that there's no rational real basis for it. That might violate people's due process rights if there's just, no reasoning behind a law. And then procedural due process is, in like criminal law, for example, where we take away someone's liberty, they have a lot of rights before you would be able to take away that liberty, right? They have a right to go to a trial and to confront their accuser and present evidence and all those things. And so those are procedural rights that everyone has a right to know what the law is, have an opportunity to, participate or comment, right? So that's due process. And then the takings clause is more specifically geared towards property, and that's where it says that the government can't take private property for some public use without paying just compensation. And that's where, our office gets involved in those kinds of disputes when there's a disagreement about what is just compensation in any case and what does the government have to pay. So short of those two restrictions, the government actually has, quite a bit of leeway as far as, passing laws that affect property. So those are from the U.S. Constitution, but those same principles are also found in the Utah Constitution, the same due process clause and the same protection against uncompensated takings. But outside of those two restrictions, the 10th Amendment of the U.S. Constitution provides that any power that's not reserved to the federal government that's not specifically delegated to the federal government is given to the states. And that's kind of what we call the police powers. And the police powers allow the government to pass general laws that affect or promote the health, safety, and welfare of its citizens. And so those are kind of the key words there is health, safety, and welfare. So whatever could be viewed as promoting the general health, safety, and welfare is usually a valid basis for passing a law. And so that not only refers to our personal conduct, such as like criminal law, but it also affects how we can use our property. And so for at least 100 years, or almost 100 years, these police powers have been interpreted to apply to zoning. So this is the United States Supreme Court case of Euclid versus Amber Realty that was decided in 1926. And this was kind of the seminal Supreme Court case that decided, yes, in fact, a zoning law, dividing up a municipality into residential districts, that's constitutional. That's a valid use of government authority. In that case, that was kind of one of the early instances of American zoning was, the town of Euclid had divided up residential zones from commercial zones. And this person lived in a residential zone, but wanted to, build a business, wanted to use it for commercial purposes. And the town prohibited him from doing that because it said, you're now in a residential zone. And he challenged that. And the Supreme Court said, that promotes the general health, safety, and welfare of the citizens. And so zoning is zoning is a valid use of police power. Let's see. So there are, where things get tricky, right, is, we've talked about the takings clause, and, that the government can't take property or property rights for public use without paying for it. And so what about regulations? Is there an extent where regulations might amount to a taking of property? And the Supreme Court has said, yes, there is a point where a regulation can be so burdensome to property rights that it could amount to a taking. The unfortunate thing is that there's not really a black and white rule of here's when it's always a taking, here's when it's not. And so the Supreme Court here back in 1922 in Pennsylvania Cole versus Mahon, they said that the general rule is that, well, property may be regulated to a certain extent. If a regulation goes too far, it'll be recognized as a taking. So the Supreme Court just kind of alluded to, there's some point where it's too far, but they didn't really give us much guidance. And subsequent Supreme Court cases have tried to nail that down further, but to no avail. And so I'll kind of explain, what the practical limits are for today's purposes of, what's a valid regulation, what's not, and how do we go about applying those regulations. So the government's kind of got to balance these two things, have to balance the kind of the general rights of the public to have, a decent ordered society and structured land uses with the individual property rights of the people that are affected by those regulations. And so that's the challenge that you as lawmakers make, is kind of trying to balance those rights. And so, we've talked to this point of, states have these police powers that aren't otherwise given to the federal government. But in turn, the state delegates that zoning power, those land use regulation powers, to counties and cities, right? So the state of Utah has done that through state statute known as the Land Use Development and Management Act, which we call LUDMA. And there's a LUDMA section for municipalities specifically, and a separate LUDMA section for counties. And so this is kind of what I consider to be kind of the guardrails or the bumpers on, within these parameters, the county can kind of pass whatever land use regulations they feel is best for the county. They just got to stay within the lane, right? The state kind of sets the outer limits, but the county's got a lot of discretion to say, here's what we think is good for our community. Let's see, find that mouse. All right, so LUDMA is found in Title 17, Chapter 27A. So that's what we'll spend a lot of our time. And so here's just kind of a very wordy slide about kind of a provision in LUDMA that kind of talks about the general authority that counties have to enact land use regulations. And it's really broad, right? It says that the purpose of LUDMA is to provide for health, safety, and welfare, and promote the prosperity, improve morals, peace and good order, comfort, convenience, aesthetics, and so on and so on. So to do all those things, subsection 2 says that the municipality, I think this one's taken from the municipality LUDMA, but counties may enact all ordinances, resolutions, rules, enter in any forms of land use controls and development agreements that they consider necessary and appropriate for the use and development of land. So again, it's really broad, right? The county's got discretion to set the law. And so when it comes down to, the role that you play as kind of in that process, we'll kind of go over that. So I think we all remember Schoolhouse Rock, right? Back in the day, talked about the, 3 basic branches of government. We've got our legislators over here that pass the law. We've got our executive over here, our executive branch. He administers and enforces the law. And then we've got the judicial branch that interprets the law. And those same 3 roles are still found in local government, even though they might be structured a little bit different. But these 3 roles, at least, are very important in land use. And there's different rules about what role you're playing. So in LUDMA, we've got some defined terms about certain players in the land use context, right? And we've got the legislative body, which that one's the easiest, right? The legislative body is the county legislative body or the county commission, right? Or the board of commissioners. So that's you guys. And then we've got the planning commission. I think we all understand what the planning commission is. That's a specific body that's separate from the commission, right? But it's required by LUDMA to be established in order to do land use regulations. And so we'll talk about their role. But then we've kind of got these other terms in LUDMA as well. We've got land use authority and appeal authority. And so the question is, well who are these? Who are these people? And honestly, the answer could differ from place to place because it's really more of a choice about what do local ordinances, who do they designate as the land use authority and who do they designate as the appeal authority? I think for just to kind of resolve the mystery, right? I think I briefly checked county ordinances, right? And so I think the land use authority in most instances is the planning commission, if I'm not mistaken, here in San Juan County. And then the appeal authority is the board of commissioners. So
We have an ALJ.
oh, you have an ALJ now? Great. Okay. So you can, there's different ways you can structure it, but we'll kind of talk about that. All right. So I'm hoping this works. So, we have a short video that I want to play for you guys that's produced by the Land Use Academy of Utah, which is kind of a coalition of stakeholders, including our office as a sponsor, as well as the League of Cities and Towns and some the Utah Land Use Institute, which you have here. You might have seen this book that's been kind of distributed. This is
The two new commissioners don't
Okay.
have that.
But I have 2 copies of these for the new commissioners, so you can kind of use this and refer to it. I encourage you to kind of share it with those that might want to check it out. But this is produced by the Utah Land Use Institute, which is a nonprofit in Utah that the book was produced with funding from the Land Use Training Fund that our office administers. But it's written by Craig Call, who was the original ombudsman when the ombudsman's office was created. He left a little over a decade ago, and so he is really knowledgeable and kind of a great, and he has a fantastic skill at writing that none of us in the current office even pretend to have. So we're happy to continue to rely on Craig for his wisdom and writing materials like this. But so this video is produced, and I'm hoping that it'll both give you a sense of what you're missing out on by having me, because it's presented by Brent Bateman, who is the former lead attorney in our office until just recently. He's now moved on to private practice, but Brent had this flair for public speaking and giving these kinds of videos and presentations, and so I want to give you a taste of that, and maybe sometimes it's a little cheesy, so maybe you're more thankful that you have me instead of him. I'll let you decide, but hopefully this works if I click on it. And just a brief video about different roles in the land use
I have
process.
the ability to help people escape reality, at least for the next week or
If you are a local government official and you're involved in making land use or zoning decisions, or if you work with those folks, what we're going to talk about today is the 3 most important things that you need to know. The decisions you make must be understood and handled correctly, or else you may violate someone's property rights or lose a lawsuit. Hello everyone, I'm Brent Bateman. I'm lead attorney in the Office of the Property Rights Ombudsman. And today we're going to be discussing what I think are the most important and fundamental aspects of land use decision making. The difference between a legislative decision, an administrative decision, and a quasi-judicial decision. If you are a city council person or a county commissioner, if you're a planning commissioner or staff, or if any of your duties in any way involve making land use or zoning decisions in your community, every decision you make is one of these 3. But these decisions are all made differently. They have different rules, and most importantly, different effects. You know, the vast majority of local government officials that I know, they want to do the right thing. They want to follow the law. They want to protect people's property rights, and they want to make the best decisions for their community. Unless you're evil, we're talking about you.
That's my favorite line.
Understanding our discussion today is the key to doing that. In my opinion, knowing what type of decision you make is the first step in making the best decision. If you will remember your high school civics class, In America and in Utah, we have 3 branches of government: the executive branch, the legislative branch, and the judicial branch. The legislative branch, which consists of our elected Congress. Their job is to take policy and make law. The executive branch, consisting of the president or governor, their job is to take the laws and enforce them. The judicial branch's job is to determine what the law is. Hopefully they're very smart, and their job is to interpret the law in case there's some kind of dispute. Locally, in your city or county, the same 3 roles exist, although they may be organized a little differently. There is a legislative branch of local government.
And this was
Their
made
job is
before
to
MAGA,
take
just to
policy,
clarify.
what
The red
citizens
hat.
in the community would like to see in their community, and to turn that into law. Those are local ordinances. The administrative role arises after the law is made, and it applies the law to different individuals or circumstances. For example, if a land use application is made, the administrative role is to apply the existing land use law to that application. And the quasi-judicial role is interpreting the local laws when there is a dispute. So let's talk for a second about each one individually and how it works locally. First, legislative. A legislative decision makes law. A legislative body does this by discussing widely applicable policy considerations and formulating laws to enforce those policies. What would we like to see in our community? Let's make a law to make that happen. Examples of legislative decisions include changing the general plan, adopting or amending ordinances, or annexation. Each local government has one body and only one body with authority to do this: the city council, town council, county council, or commission. No one else. And the standard of review is reasonably debatable that it advances the purposes of LUDMA. That's a low standard. A decision need only be reasonably debatable that it is good for the local community, and it will be upheld. Next, an administrative decision. An administrative decision applies the law. There are no policy considerations in an administrative decision. There's no, is this a good idea, or does this work here? Those decisions have already been made and placed in the local code. An administrative decision takes an application and applies the existing law to it. Examples include subdivision, or a conditional use permit, or a building permit. An administrative decision can be made by any party that the legislative body appoints. Many administrative decisions are made by staff. Sometimes they are made by a planning commission, but they do not have to be. They can be made by any party appointed to the task. And the standard of review is substantial evidence on the record. If an administrative decision is supported by substantial evidence, it will be upheld. And finally, the quasi-judicial decision. A quasi-judicial decision comes into play in the case of a dispute, and it interprets the law. Every local government must appoint a person or body to handle this role, called a local appeal authority. Many places use boards of adjustment for this role, but that is not required. That's a quick overview of the 3 types of decisions and the differences between them. There are a lot of nuances we haven't discussed, but that's okay. This is enough to get started. Every time you make a land use decision, you have to think about the type of decision it is. Every time. If you'll do that, you'll greatly increase your likelihood of making the best decision. And hey, if you're going to make the best decision, hats off to you.
Okay. Thank you, Brent. You might be thankful that you don't have more of that today. Or maybe you're wishing you had more. I don't know. Let's see if I can. Okay. See, how am I going to get back to...
A diaper this leak-free sets them free. Only Pampers Cruisers 360
Hard
have
to
a
see the mouse.
360
Let's
stretchy
see.
waistband for up to 100% leak-free.
Okay. So is this in the way up here?
No, if you click the 11723, it'll come to the forefront.
Oh, I see up there.
Can you get out of there?
Yeah, just...
Right there.
Click on the next one to the left. I see you might have to go back.
Go out of YouTube.
Let's see if I can.
Let's see here. Let me see your mouse.
Sorry, it's just kind of hard to see. Need glasses, I guess.
We've got a screen in the way. Let's see here.
Okay, okay, thank you.
Scroll too far.
So I want to go back to that previous slide where we got the players, right? So as Brent kind of went over, I like the video because I like the hat illustration because, I mean, honestly, I think that our office, we made that video not for the cities that have, fully staffed, city council, planning commission, and, land use authorities, but for those that I think like here in San Juan County where maybe you're playing both roles, right? Where you're switching hats back and forth. And that's why I like the hat analogies that it's good to remember in any meeting that you're in, okay, which hat are we putting on right now? Are we here as the, county commission to pass law? And so we've got the legislative hat on, but are we reviewing a land use application as the designated land use authority in the code? If so, we're doing an administrative decision. We have to keep those roles separate because the purposes of those roles are different. So, so the planning commission, right? They do play a role in the legislative process, and the planning commission's role in the legislative process is to just simply make recommendations to the legislative body. So they make recommendations on, as the name implies, they're planners, right? That's the planning commission. Their job is to make a general plan. They're to recommend certain land use regulations, which include rezones, and then they also make a recommendation on when the code designates a land use authority or an appeal authority, which should already be, in place. And so, it's not for any single application or any single appeal we're going to decide who's going to decide it. It's the code already designates who the land use authority and the appeal authority are. And so, so when we talk about general plan or enacting general plan, that's when we're getting all of the data and we're taking into account all of the preferences of the community or the factual data about what would make good planning, and the legislative body makes a decision that they feel is in the best of the community. And that's where he says that the standard for those kind of decisions is really low, right? It just has to be reasonably debatable that it serves that general health, safety, and general welfare. So that's, the commission's got a lot of discretion to say in passing a law, this is what we like. Here's what the community thinks. We're going to take that into account. We're going to take into account the recommendation of the planning commission, and we're going to pass an ordinance, right? So I don't want to spend too much time on that. These are just kind of some best practices, but I think I want to talk more about the administrative process, right? Let's see. Okay, but one thing I do want to hammer in is the discretion, right? And at the legislative process, when you're passing the law, there's a lot of discretion to determine what's good for the community. Now, so after the law's in place and it's kind of set in stone to say, which isn't to say that it couldn't be changed later, but the law's there, and then someone comes into the county with an application and says, I want to apply that law to my property. I want to get a permit, right? That's where we now switch hats and start playing the administrative role and make an administrative decision. And so this is anything from subdivisions, site plans, conditional use permits, building permits, any time where someone's getting some sort of approval, right, other than, a rezone. A rezone is a legislative decision because it's changing the law that applies to the property. Administrative decisions are taking the existing zoning, existing law, and applying it to the property. So who reviews an administrative land use application? It's the designated land use authority, and that might be, in some instances, it could be the county commission, and that's why it's important to remember which hat you're playing. Is if you're designated in the code as the person or the body to make a land use decision, then you're making an administrative decision. So what are the standards? What do you have to do as far as what is your discretion? Well, different from the legislative side of things, the discretion in the administrative process is not really, I mean, it's whatever the code is designated to you. So it's not an instance where you're looking at things and saying, do people like this? Do we like this? Is this something that we think will be good for the community? Those decisions were already made when the law was passed that either created the zone or created that particular land use or that density, right? And now it's just a question of someone wants to get an application approved. Do they meet the requirements? It's more of the checklist. Do they meet everything that the code already spells out? And so that's why LEDMA says that, the standards, it says the county is bound by the terms and standards of applicable land use regulations and shall comply with mandatory provisions of those regulations. So if this code spells out, here are the circumstances under which someone can be approved, that's what you follow. Now, some administrative codes, right, or some land use codes, they try to delegate a little bit of discretion to the land use authority, say that, in some instances they may approve this, or maybe it might write into code some sort of exception or waiver where you can, maybe change a setback or a little bit of density or something. Well, as long as it's clearly spelled out in the code and here's the circumstances under which you can make that decision, then whatever discretion it gives you, that's the discretion you have. But again, you're still trying to follow what the code says, and it's not an opportunity to kind of reinvent the wheel as far as, do we like this or do we not, right? And so when making an administrative decision, the standard of review, or kind of the standard of what is a good decision, is you have to support it by substantial evidence in the record. And so substantial evidence just means that you have to provide sufficient reasons or evidence that kind of supports your conclusion, right? So here's what courts have kind of defined substantial evidence to mean. It says substantial evidence is that quantum and quality of relevant evidence that's adequate to convince a reasonable mind to support a conclusion. So again, not a terribly high standard, but still you have to at least show your work, right? I think that's what it's getting at. And so and here's another case that says it's more than a scintilla or a small amount of evidence, though something less than the weight of the evidence. So it's not like you got to prove by, it's not beyond a reasonable doubt. It's not criminal law. You just have to show that there's evidence to support your decision and that a reasonable mind would be convinced of that conclusion. So for example, it says the land use authority may require the developer to include stub roads to parcels that will otherwise be landlocked as a result of the development. That makes sense. You can see the reasons behind that kind of requirement. You have to make sure that the evidence is in the record. So, it's got to be reflected in the minutes, right? Or, you got to explain the reasoning on the record at least, so that there's a record that can be taken up on appeal if needed. And because that's what's going to form the basis of what the appeal authority is going to look at, is what's in the record. So how does it work in practice? What's kind of the practical application? So let's say we've got a subdivision application. Property owner wants to subdivide their land and create a residential development. So the land use authority receives that and looks at the code, and they identify what's the current zoning of that property, right? If it's something like if the person had brought in a commercial application and it's zoned residential, and residential doesn't allow certain conditional or commercial uses, right? Then maybe that property owner is going to have to get a rezone first. So that's kind of the two outcomes: is if does the zone allow it? If no, then they might have to, if they really want what they're proposing, then the law is going to have to change, right? They're either going to have it rezoned to a different zone district, or if it's a particular provision in the zoning text, they can ask for the council to amend the text, right? But if the zone allows what they're proposing, then you move the application forward and make sure they meet the requirements. So So if it does not allow it, they have to kind of, like I said, come through the legislative process. So what's that process look like, right? Going back, now we're going back to the legislative process. The property owner needs to rezone their property or ask for text amendment. The application first comes to the Planning Commission for recommendation. Planning Commission makes their recommendation after holding a public hearing, listening to what the public wants, right? What the public has to say. And then they, look at their general plan. The general plan is kind of meant to anticipate, here's what we expect development to be in the future and here's where we want it. But the general plan it's an advisory document. It's not mandatory, right? And so even if the general plan anticipates, higher density residential uses, and that's what the property owner is asking for a rezone for, it might not be the right time, right? There might be, the county might not be ready for that kind of development, and so when we're talking about rezone, because it's a legislative decision, again, there's discretion, right? The county can say, you know what, we don't want this right now, or we do want this right now for any number of reasons, right? And they've got that discretion to make that kind of decision. And it also involves, the public has a say, right? They you hold a public hearing and the public says, here's what we like or don't like. And again, the legislative body can take that into account. They can take the Planning Commission's recommendation into account, and they can ultimately choose to either approve it as it was proposed, or they can reject it, or they can, even make modifications to it and approve it as they see fit. And so they don't have to listen to the Planning Commission's recommendation, or they don't have to necessarily listen to what the public comment was, right, or the community was. Obviously, you are elected officials, right? So you want to not make too many enemies, right? But your job is to do what's best for the county. And sometimes, there might be a vocal minority in a lot of instances that may not reflect what from all of the experts and all of the planning documents and Planning Commission to kind of be good for the community. So going back, so if the zoning does allow what the property owner wants to get approval for, then you keep going with the administrative process. And so how it works is when the application's received, there's an initial review to determine that the application's complete. And that's not really getting into the substance of the application. That's just looking only at form, making sure that if the county requires that certain forms be completed, that those have all been received. If it requires a site plan, that's received. Fees are paid, those kinds of things. And that can be done by staff, right? Staff takes the application, does the checklist, says, okay, we've got everything we need to then make a decision. And there's important concepts along this way to keep in mind as far as the property owner's rights. And one of those is what we call the vested rights rule, right? And that's the idea that if a property owner submits a complete application, that day that they submit a complete application is the day in which they vest as to the ordinances that are in effect at that time. So that's getting at the idea that if someone were to turn in an application and then the county were to turn around and change the law in a way that would affect whether they could be approved, the law kind of protects them from the law changing after the fact, after they've submitted an application. They're vested to have their application approved as the ordinances were at the time they applied. And then so once the application's complete, then there's a substantive review in the application. That's where the land use authority, whoever's designated to be the land use authority, they review the substance and they approve or deny it based on what their code says. And the important rule to keep in mind is when that decision's being made is that you apply the plain language of your zoning ordinances. So LEDMA says that the land use authority must apply the plain language of its ordinances. If a regulation does not plainly restrict a land use application, it must be interpreted and applied to favor the application. So what that's getting at is if there's an ambiguity in your code, meaning that it could be read one of two ways, we kind of refer that as the tie goes to the property owner, right? But that only comes into play if there is an ambiguity. Your primary responsibility is to just apply the plain language. If it's clear what the code allows and what it doesn't, you follow that. Even, if you think it should be otherwise, the time to change the law is not for that application, right? So So here's kind of the process that courts go through when they try to interpret the meaning of an ordinance, because sometimes the meaning's not always clear, right? And that's what, either when we're asked to do an advisory opinion, a lot of times we're asked to kind of resolve disputes about competing meanings, right? The property owner thinks that the code means one thing, and the county staff or the county commission might believe that it says a different thing. And so either we're resolved to do that, or if it's litigated, the courts have to resolve that dispute. And so again, the goal in ordinance interpretation is to discern the intent of the legislative body. What did the legislative body have in mind when they passed the ordinance? And the way that courts arrive at that intent is looking at plain language, right? They look at the text of the ordinance, and that's kind of the best indication of intent. And so they don't really dig into legislative history if they don't need to, right? If it's plainly written, that's the meaning. Even if maybe, because we know how the legislative process works. If we look at either Congress or the state legislature, we refer to that process as how the sausage is made, right? I mean, there's all sorts of going back and forth and kind of bargaining and things that before you get to the final product. And so even if a bill sponsor had a certain intent when they started, that may not have been the ultimate product that resulted, right? So the intent of the law is what the language is, right? But if the language is ambiguous, like I said, meaning that there's two or more plausible meanings, then that's when it's resolved. You do the tie to the property owner. And so what the Utah Supreme Court has said is that because zoning ordinances are in derogation of a property owner's common law right to unrestricted use of his or her property, provisions therein restricting property uses should be strictly construed, and provisions permitting property uses should be liberally construed in favor of the property owner. So if there is a dispute, you look at if the provisions has the effect of being more restrictive on property uses, then you look at that very strictly. You try to kind of interpret it narrowly, right? Or if the provision is arguably allowing a particular use, right, then you look at that kind of liberally, right? And so we sum that up by just saying that the tie goes to the property owner, right? If there's a real ambiguity in the meaning of the ordinances. Other issues of rights along the process, right? So there's what we call legal nonconforming or grandfathered rights. That's the idea that someone that starts using their property in a way that's legal at the time, or they erect a structure that was legally permitted under the zoning at that time, as they, go on over time, the zoning might change, right, and might prohibit that kind of a building, or maybe the law changed so that kind of use is no longer permitted. And those people have a protected right to continue doing what they're doing with their property as long as it was legal at the time they began it. They've got a grandfather right to continue doing that. And that does have limitations. State law says that local governments can in their ordinances establish kind of the limits of that. So it might be that you might amortize it over a period of time. You have to just make sure that they can recoup their investment in their property. But honestly, a lot of governments don't really even touch amortization. They just let that be. They just let property owners have a grandfathered right, and as long as they're not, expanding on the use, that if you've got a non-conforming structure, you can keep that structure, but you can't build an addition on it. You can't, otherwise change it materially. If you've got a use, you can continue that use, but you can't increase the intensity of it. You can't change it to another non-conforming use. And if the property owner abandons that use or they demolish the structure voluntarily, then they lose that grandfathered right. They can't rebuild or resume that use later if it's now prohibited. If it's destroyed by fire or something, then they can rebuild. But I guess I need to go to the next slide here. Sorry about that. So grandfathered rights. And then the other thing that doesn't come up as often, but is still important to know is, let's say that someone does get a land use approval. Let's say they're doing a subdivision and they get a preliminary plat approval. Well, is that approval good forever? And the answer is probably not. What state law says is that the continued validity of that approval is contingent on the property owner proceeding with reasonable diligence to implement the approval. In other words, if the approval says, here's a preliminary plat approval, the next step is you got to get final plat approval, and they never do anything else, they never come back for final plat approval. State law just says that it's reasonable diligence, and so that could be a different thing in different circumstances based on what the property owner was doing. But I think more relevant is a lot of local code will establish deadlines. You know, local code will say preliminary plats expire if you don't get final plat within 1 year or 2 years or X number of months, 6 months. And if that's what the local code says, then that's valid, right? So if an approval is given and it's not really implemented, right, it can expire at some certain point, but doesn't really come up a lot, but it is something that does come up. So, so there's other more, I guess, subject specific topics we can go over. Conditional uses, that's kind of a special administrative decision that kind of has a little bit of its own rules. I think maybe before I go on, is there any immediate questions at this point that you kind of want me to hone in on, or? Because I want it to be more relevant to you guys. I don't want to, go over things
question.
that. Yeah.
Let's use what we have on the agenda for the commission meeting today. We have a few properties.
Mhm.
I just want to know what stage of the sausage is the. Are we here still taking it apart, or are we have a different hat? Or we just. So I assume that through the other steps process, I guess all these steps have been taken care of, like the zoning application.
Yep.
The things are in order. Am I right? And so I try to understand which hat because as I go through the agenda, there's different hat. I have to
Right.
keep switching, and so I just want. So what we had today is basically has gone through the process of those steps, and now we are into the basically just
Item 12,
the approval. I mean, stamping. It has gone through
12 to 15.
public hearing. It has gone through everything. So
Yeah. No.
can
Yeah.
somebody?
Yeah, so everything on the agenda today is all subdivisions.
Okay.
New subdivisions or amendments. So they have gone through preliminary plat at the
Okay.
planning commission and final plat approval. Well, before that, initial review by staff, and then preliminary and final with the planning commission. And then, yeah, they're here for your approval.
Okay, so
Basically, you're applying the subdivision ordinance, the code that allows you to subdivide certain lot sizes, everything else, but you're applying that to you're not creating a law, not legislative.
So basically, my question is, so I don't have to worry about, can we follow the law here? That's have been taken care, and basically, it's just, I'm just excited that we can have more income coming. I don't know, but
Yeah. So yeah, great question. And so yeah, a subdivision at all stages of the subdivision, we would look at that as an administrator decision. The only, the legislative process would be enacting the zoning, the underlying zoning to begin
So
with,
that's-
right? The zone that says, that it's
Okay.
going to be, 1 acre lots, or it's going to be, here's the setbacks.
okay,
That's all been decided, right? When we're talking about
Okay.
legislative decisions. But when someone then comes and submits an application for a permit, right? Anything that requires a permit is going to be administrative. And really, I mean, the only time that a property owner might initiate some sort of legislative process is really to ask for a rezone, right? And sometimes, developers will want a specific text amendment, so they might be the one that kind of gets the process going. But, for the most part, the county probably self-initiates text amendments as they see fit, or as state legislature, rewrites all the rules and turns things upside down, and you have to keep up to date. So,
So Scott, when when a decision needs to be made on a subdivision and you bring it to us, you've done all of the background work, all of the homework. You're just here for us to make that final decision so they can go ahead and complete the project.
And it's for you to decide if there is any additional, because there is some in our code, there is some, if you want to enter in a development agreement or anything, that agreement is with the county commission, not
Right.
the planning commission. So if you feel it's necessary to have we may have that discussion and they recommend that to you,
Mm-hmm.
but ultimately that decision for like or any other conditions or anything you might it could apply, that I think, right, that's the power of the
But in the past, you've brought these things to us and you've said to us, we've presented this to the Planning Commission. The Planning Commission has approved it. We're recommending that the county commission approve it. That meaning you vetted the whole thing through your processes and you're just bringing it to us for a final decision.
And that's my question.
Yeah.
right. So
Question on that. When you're vetting this, are you bringing in the other side of from land use to state water rights, your local jurisdictional water and sewer? Do they have, so you vetting that and bring or the commissioners looking at it from a land use from planning and zoning recommendation, and then they're looking at it from maybe your health department or your, is that part of your process when you bring it to them?
So when we bring it, we basically, every county department looks at it. The road department looks at it, the health department looks at it, the surveyors look at it, the recorder's office looks at it, all of them.
Right.
Everybody looks at it and makes sure. And some that we have, a couple health service districts who probably need to be better, primarily Spanish Valley. I usually encourage people to get with this special service district, but we haven't necessarily been including them as soon as we receive applications. So we've asked the applicant to do that side of it, get that groundwork done with special service district. Before it comes here. But the majority of that we get are, well, we get a lot from special service district, but others we get are just out with their own well and they're on their own septic.
Right.
In San Juan County, for right now, we have an open aquifer, meaning that if you have property and you want to, you can apply and the state will give you a water right, a well permit to drill. You can drill. The rest of the state, a lot of it's a closed aquifer, so you have to buy the rights, you have to acquire the rights from someone who has them already. You can go get your rights here in San Juan County. So we've had this discussion, and I did, this is on another topic, but whether or not we should require people to have those rights ahead of time, where we have an open aquifer and people can just go get the rights to drill water. So anyway, as of right now, we haven't required water, but yeah, that we're trying to get everything that from that perspective where it comes to, I guess, the water.
And that include public hearing? I mean,
If it's required, so a public hearing is only required for like legislative processes.
okay, but not for approval of the.
No, that's a great point, and one thing that so that video that Brent made, he made two other parts after that where he kind of goes into other topics, and one of those is kind of how to engage with the public, and so that's a great point. So the public hearing is a requirement for any legislative process, and so it's not required for any administrative process, and you can see maybe why, right? Because a property owner has the right to develop according to the code, right? And so whether or not their neighbors like it doesn't really affect their rights. However, there are instances where maybe local ordinance may require a public hearing if you choose. So the county, in other words, they can choose to require public hearing for something like a conditional use permit or a subdivision, possibly, right? But it's not required. But that isn't to say that the public doesn't have anything valuable to contribute in an administrative process. One thing that we haven't gone into yet is conditional uses. Conditional uses are kind of the special application of an administrative process where you approve it, but you also have the opportunity to impose conditions for specific reasons. And the reasons are to try try to mitigate impacts that the proposed use might have, right? And so in that kind of a process where there's a little more discretion in determining how you're going to approve something instead of just checking boxes, but you're coming up with conditions that you feel are necessary according to the code, you know, the public might be a good source of evidence as far as what those impacts might be, right, or what they have been, right? But yeah, so unless your code allows it, there's not really, I mean, all meetings are done as a public meeting. So the difference between public meeting, public hearing is a public meeting is this meeting, right? Where anybody could walk in and view the proceedings, right? That's open to the public. But the difference with the public hearing is a hearing gives an opportunity to comment from the public. In a public meeting, there's not really an opportunity to comment unless the county opens it up, right?
Thank you.
About that unconditional uses. We've had some disagreement in the past. The state code does not require public hearings for conditional uses.
Right.
Our attorney's office has allowed it. Kind of gives the public more opportunity to express their concerns at that time.
Right.
The other side of that is then you're inviting comment on something that kind of becomes public clamor and not really relevant to the decision.
Absolutely.
The decision has to be approved if appropriate conditions can be imposed.
Scott, do you think we could have the attorney's office hold a public hearing and then report back to you and you could report to us?
No, it's, yeah. So yeah, with conditional uses, you know, there are pros and cons, right? I mean, and I think you identified some of the pros is that I think the community likes to be, you know, involved, right? They like the opportunity to kind of express their concerns. But the danger is that what we see often is when you do open up public comment for something like a conditional use permit, when you get an overwhelming response of opposition, you get tempted to forget which hat you're wearing, and you maybe start going into policy mode and saying, gee, the public really doesn't like this. I don't like this. I don't think this is going to be a good use of property for the community. I'm going to vote to deny it. And in doing so, you know, you're likely violating the property owner's rights to develop if the basis for the denial of a conditional use permit is nothing more than public clamor, is what the law says. Public clamor is just public opposition, you know, that doesn't really have any factual basis in the code. Because conditional uses, you know, you identify what could possibly be detrimental impacts in your code. So, you know, you might have in your code that the planning commission or the land use authority can impose conditions to address parking or can address noise or something like that. And those are those limit what you can impose a condition on. You couldn't just make up a condition that's not based on your code. And so that's the danger with public comment is that, you know, denying permits because of public clamor, not because of reasons in the code that conditional use couldn't be approved. Because the standard for approving a conditional use, just to kind of quickly do it, is that it shall be approved. Sorry, I keep forgetting which. State law says conditional uses shall be approved if reasonable conditions are proposed or can be imposed to mitigate the reasonably anticipated detrimental effects of the proposed use in accordance with applicable standards. What that just means is that, you know, the only time that you could really deny a conditional use permit is if there were simply no conditions ever that you could propose to mitigate what these impacts are, right? So, you know, I can't really point you to a lot of examples in maybe like, you know, disputes that have kind of gone up to appellate courts. I think there was one recently where the court did affirm a denial of a conditional use permit because the effects couldn't be mitigated. But in most cases, I mean, there's got to be some conditions you could impose to kind of ameliorate the effects, right? So,
I have a question. You mentioned text amendment. How does that differ from a regular amendment to either a zoning ordinance or a subdivision ordinance?
I mean, I think it's the same, right? We're talking about any time you're amending a zoning ordinance to change one of its provisions, right? Changing the actual text. In other words, you're either bumping up density or you're moving a setback requirement, right? you know,
So it's just the regular process.
regular process, right? One thing, and I don't want to open a can of worms, but but I would say that probably the most controversial topic that we deal with in the administrative process are exactions. And a development exaction is the idea of, you know, up to this point, we've all talked about kind of laws that might restrict the use of property, right? But you might also have either a condition imposed in the administrative process, or it could be written into your code, something that requires a property owner to actually give up property to the government or to contribute to public infrastructure by paying for something like roads. Anytime the property owner is giving something, either money or property, to the government, that's called the development exaction. And there's a little bit of a heightened standard on that kind of a condition or requirement, more so than just regular restrictions on land use, because they're actually giving something to the government, right? And going back to the takings clause, right? The takings clause says that the government won't take private property for public use without just compensation. And so exactions is kind of this area where the government is essentially taking property or taking money, but not necessarily paying for it, because it's imposed in the development process, specifically because it's aimed at you're trying to offset the impact that development has to the community. In other words, the reason why the government's not flat out paying for a road is because the idea is that the proposed development is adding impacts to local roads, and so they're paying their share of development, right? As you know, the community develops. And so so exactions can be imposed at, you know, the subdivision stage or any other permit stage, right? If there's some sort of impact to public infrastructure that needs to be offset by the development. And the idea is that the law requires that you know, property owners can't be asked to pay more than their equitable share, right? So going back to kind of the purpose of the takings clause, this comes from the United States Supreme Court, says the primary role of the takings clause is to bar the government from forcing some people alone to bear public burdens, which in all fairness and justice should be borne by the public as a whole. So kind of where exactions can get local governments in trouble is when they start using developers coming in as an opportunity to just further their own transportation plans by, hey, we want a road here in the future, we're going to make you pay for it, and not really making that connection between what's their impact, right? Or making them put in a whole road or something, right? So kind of the standard is an exaction is valid and proportionate when it offsets the cost of the local government of a development's impact. An excessive exaction requires the development to pay for impacts beyond his own development activity. And so it's kind of a really gray standard, right? I mean, it's more of a case-by-case basis as far as what would be a valid exaction in any given case. And that's why it causes a lot of disputes that come to either our office. A lot of them don't go up on appeal. I mean, really the extent of our court knowledge on exactions is a series of cases. This Banbury development versus South Jordan you see here. This party that was developing in, I believe is in Kearns, they were asked to, it was a residential subdivision, they were asked to basically widen a road in front of the subdivision. They went up on appeal 3 separate times. And so there's 3 Supreme Court opinions just from this one development. And that's kind of the extent of Utah law as far as what we know about exactions from what the court has said. And you know, the requirement in LUDMA is that you can impose an exaction if there's an essential link between like some government purpose and what condition you're asking for, and that the condition is roughly proportionate in nature and extent to the development of the proposed impact. And so
on the exactions, if you were to impose, like each property, commercial property or whatever, retain their own water through a retention pond or a retention basin,
right?
Is that considered an exaction where it's on their property? You're really not taking it, but you're requiring them to have that stormwater retention in place so it doesn't jeopardize and damage adjacent property owners through that development.
Right. And so that could be an exaction if, let's say, if you made that, if you're basically asking for
an easement, right? Or if you're
It's just a requirement that
Yeah.
they, so say for example, they build a Walmart, and Walmart has all that surface area on its roof system. So now it collects all that rainwater, and rainwater is all funneled down to one spigot. And from that spigot, you're like, okay, you're going to have to retain this water on your property so you don't flood out your neighbors. And so because of that, we require an underground vault to retain it, or a retention pond up on the surface. To me, I just see that as not really an exaction, but it is a requirement that takes their footprint.
Yeah, so it's more of a project improvement, right? But yeah,
Yeah.
so is that so? I mean, it could
More
be an exaction
mitigation.
if the government said like you have to deed us a certain amount of your
Yeah.
property so that we can have a retention pond. So yeah, an
then
exaction.
They've got to retain their own water instead
Right.
of flooding out their neighbor.
Right. So the quintessential exaction are road improvements, right? So if
Okay.
you require a developer to either improve the road in front of their property by putting in, half a width of road, curb, gutter, and sidewalk, right? Or if you require the property owner to widen a road because of their development, anytime you're requiring them to either give you their property, dedicate property, or you're asking them to, to pay for public infrastructure, right? That's going to be used as a system improvement, right? That's an exaction. And so the extent is you
But
can
it's still
ask them,
allowed, as
you
long
can-
as it's not
yeah. So
extenuous.
So the kind of the rule of thumb that we've tried to identify to kind of illustrate it is if we're talking about like a local road, if properties are all abutting a local road that's maybe unimproved, right? And city standards say that new development has to improve roads, right? Then as long as each property is developing their half width in front of their frontage, right? Then ideally everybody's pitching in equally, right? They're only putting in what's along their property. And that might be an example of a valid exaction. But if you either require a single developer to improve a whole road that's really going to, kind of benefit another property owner that didn't have to contribute to it, or if let's say the road running in front of the developer's property is an arterial road that's used by the whole community, and you make them put in a half width that might, they arguably have an impact on that road, but their share of that impact might be, 5% of the community's use of the road, right? They might constitute 5%. That's what happened in Vanbury, is we're talking about in Salt Lake County, a major arterial 5600 south, and the development, the fact-finding process in the court was basically they concluded that the subdivision's share of the traffic on the road was 5%. And so the question is, well, does that 5% match up with however much they were asked to contribute? Are they contributing their fair share, or are they going beyond their share?
Okay.
So now that you're all confused about exactions,
No, that was helpful.
I'm happy to answer any other questions you have, or if there's a specific topic that you're considering or thinking about in your land use planning that you want to discuss. We're happy to, or state law changes that may have recently happened or that you've heard might be coming up. I'm happy to discuss those as well. So
Overnight rentals.
short-term rentals.
Yeah, that one. I understand that there's a new bill coming up this legislative session to kind of put a moratorium if you're running an overnight rental in a municipality. There's a pilot program that they're trying to create where if you're not properly zoned, that will kind of be forgiven in an effort to enter into this pilot program. I don't know if you're tracking that legislative bill or not. That was one of the things that we're kind of following. We have, an issue and concern with overnight rentals here in San Juan County where they're just popping up anywhere and everywhere. Trying to get ahead of it to where we can potentially create zones and allowances for it in certain areas, but they're everywhere. And
No, that short-term rentals are a hot topic right now, and so it is something where, kind of going back to that legislative process, currently state law doesn't really give you any guardrails on short-term rentals. So you can designate them to one zone, you can outlaw them, you can allow them, you can condition them, you can require a license, those kind of things. And They are popping up everywhere. So one of the issues that our office has seen is the question of non-conforming rights or grandfathered rights when if the code didn't really say anything about short-term rentals to begin with, and then suddenly the county passes an ordinance and someone says, I've been using my property as a short-term rental for 20 years, then, that's a question of, do they have grandfathered rights? And kind of going back to, in absence of zoning, right? If you didn't have any zoning in place, a property owner would have a common law right to do whatever they wished with their property, right? So the idea is that a property owner is only restricted from a certain use of their property if it's plainly stated in a land use ordinance, right? So our office has had the occasion to give opinions about whether a particular property owners had a grandfathered right to short-term rentals when they weren't really spelled out in the code before, but were later amended to prohibit them. And in those circumstances, the answer was yes in those opinions. But yeah, as far as state law going forward, right? There is a bill. It's House Bill 291. Calvin Musselman, Representative Calvin Musselman.
He's from here. You know that?
Oh yeah,
That's awesome.
yeah.
Bruce taught him.
There you go.
Commissioner Adams taught him. Yep.
So yeah, so there's the only thing state law does say currently, right, is that it does prohibit municipalities from enacting an ordinance whose sole purpose is really to just prohibit the listing of a short-term rental on a website, right? And that's caused some confusion. So his bill tries to clarify that a little further, but we've always understood it. And I think what his bill tries to clarify it is this idea that if the ordinance is really only getting at the listing, then what you're really regulating is speech. You're not really regulating use of property, because someone might list their property for sale but never actually rent it out.
Yeah.
So if you fine them or if you charge them criminally for listing on a website, then you're not really regulating the use of land. You're prohibiting speech. And so this bill is trying to clarify that you can't do it solely for that purpose. You could still use short-term rental websites as evidence, that maybe someone had actually stayed there, in which case, if they did actually stay there, then you can enforce an ordinance that otherwise had prohibited, that kind of a rental.
I don't think there's much opposition to it unless it comes from the league.
The bill?
Yeah.
Yeah.
I think some of them are worried because it, and there's a specific word in there. It's where it kind of grandfathers them in. It forgives them for.
Yeah, amnesty is the word it uses.
So it offers up amnesty to these overnight rental
and
entities or individuals.
And I haven't read it too closely, but I think my understanding when I read through it was that I think all that amnesty and all those provisions apply to this pilot program. And so I think it's something that the local governments can choose to enter into. So I don't think it's anything being forced on local government that they've got to grandfather everybody in, but it's if they want to do this pilot program, then yes, they do have to grandfather everybody.
Yeah. Okay. Yeah, that was.
What's involved in getting an advisory opinion? What's involved? How long does it take?
Great. No, that's a great question. So as I said, our office can issue an advisory opinion on certain topics, and they're really all related to land use applications. So the administrative process, if there's an application that's either approved or denied, that decision to approve or deny it, we can independently review that decision and determine whether that decision complied with the local code and state law. And so the process is we just have a form that the opinion can be requested by either the applicant or a third-party neighbor can request it, or the county can request it, or the local government. And there's the only cost in our office is just for an advisory opinion. It's a filing fee of $150, and that's the only cost for any service in our office. Otherwise, we're all funded by Commerce. Yeah. So, and so the process of how long it takes. I always answer it doesn't take as long as litigation, but it's also not a quick answer either, because there's only 3 attorneys in our office, and we have probably 20 opinions waiting at any given time to kind of get through. And so part of the wait is allowing the parties to kind of reply to each other and give us their arguments and their evidence. But as soon as everyone said what they need to say, and then we've got it in our queue, it just depends on how many opinions we have in front of it to get for. But I think the total process at this point takes about 4 months, a few months to get through. But
Is that more of a recommended process to go through rather than make the decision and have the individuals appeal it, and then it go to an administrative law judge that then does the same exact thing, considers both parties and
Yeah.
looks at the evidence on both sides and then makes a judgment off of that?
yeah, so our process is kind of it's an
Administrative
alternative
process.
dispute resolution procedure, right? So
Okay.
so we don't substitute for the appeal authority. In fact, our jurisdiction to issue an opinion ends as soon as the appeal authority has made a decision. So if somebody submits an appeal, the latest they could request an opinion through our office is at any time before the appeal authority has made a decision.
Okay.
At the point the appeal authority makes a decision and it's otherwise ready to go to court, as soon as it's ready to go to court, it's out of our hands. We're meant to because that's the whole purpose, right? We're supposed to be available to kind of give the parties, here's an independent answer so you don't have to go to court.
Yeah, absolutely.
But
Which
but
is
it,
awesome for
yeah.
$150.
Potentially, though, that could put an applicant on hold if they're concerned about that.
Well, so what our statute says is that when the application or when the advisory opinion is requested by the applicant, it doesn't stay the application. It can still move forward. And we just, again, operate independent from the appeal process. So,
Okay.
I mean, a lot of times our opinion will come after the appeal authority's made a decision, but
What if the county requests something, like
It-
we're
yeah.
waiting to make a decision on something, we want an opinion, and it's 4 months out? Is that an issue with us saying we're not gonna make an application for 4 months until we get this?
so our statute, it does say that if the opinion's requested by the government, then it does stay the application. In other words, so, if the county really wants an answer on something and, they don't want to have to force a decision before they get some guidance, then the statute does allow the application to be put on hold while we do the opinion.
Okay. And there's no retribution or anything with them if you're holding out development. It's costing them $1,000 a day, $1,000 a night.
I mean, not for that stage of the
days.
process. So the
Okay.
consequences of our opinion, kind of the teeth that our opinion has is that, I mean, it is non-binding on the parties. However, if we issue an opinion and let's say that we say that the government made a mistake, right? And if the government doesn't change course, right? If they say, we don't agree with the ombudsman, we're just going to keep doing what we're doing. If the property owner were to take that process further and litigate it, if a district court rules the same way that we did in our opinion, then it opens up the possibility to recover attorney's fees as well as a daily fine. This was added a few years ago to our statute, a daily fine of $250 for every day that the government didn't comply with our opinion after 30 days of issuance.
Oh, wow. Okay.
But and that goes both ways too. So I mean,
Yeah.
I don't know in what circumstance this would really work in real life, but theoretically, if we ruled in favor of the local government, and they could also recover attorney's fees if the court ruled the same way we did,
Okay.
if the dispute continued. So
I got a question on non-conforming.
yeah.
Can the county amend for the state statute on that? Because I look at, like, my biggest heartburn with it is somebody that's owned a piece of property for 20 years, and they say they have a 5-acre piece, they started a business, they're in a commercial zone, they start a business, wanting to expand as they go on as their business grows.
Mhm.
You get a bunch of people that move in from out of town, build residence around it. Well, they go in, the county changes the ordinance for the residents that moved in after,
Mhm.
and now they're non-conforming. They can no longer expand. If the EPA comes in and requires them to do certain things for the business to still be in place, well, now they can't expand because they're non-conforming. Their business is shut down.
Yeah, I don't know if I can answer kind of the EPA aspect of it, right? Basically, you're saying that other law would require you to expand in some fashion. That I mean, I think we'd have to look at a particular instance, right? But the general idea is that, a grandfathered right allows you to it's kind of a moment in time, right? Because otherwise, zoning can change all the time, right? And so let's say because this happens all the time where someone owns land, they're banking on that as their retirement. They say, I'm going to build my retirement home, right? And then they hold on to it for 15 years. But there's no guarantee that at some time between now and the time that they're actually ready to develop, that zoning might not allow them to do what they're going to do. Even if at the time they bought it, zoning allows, them to build a 5-acre residential home or something. If they get down to it and zoning changes before they submit an application, then that's, they vest that to the time that they actually submit an application. So that kind of goes with the same principle, right? I mean, if zoning law changes in a way that would not allow you to continue to expand, right? I mean, you have a grandfather right to have what you have, but you have to comply with zoning going forward for any time you're asking for a permit approval, right?
Right. So, the court case with, I believe it was Geneva Rock.
Mm-hmm.
With
the mining rights.
Everybody moved in around them and tried to change it.
Yeah, and Sandy, that happened.
They considered it where they could not change the ordinance because they've been there. It's precious materials.
Mm-hmm. Yeah, and you'll notice that that gravel pits kind of get their own special rules a little
They are
bit. And,
protected.
and that's an instance where maybe state law comes in and changes the bumpers a little bit and says, here's your lane now. When it comes to mining rights, here's what you can and can't do. And that happens with any, industry that's kind of more lobbied or, given a little more attention. Billboards is another area where billboards have their own sets of rules for everything. And
Airports
that's
about the same thing. That there's a bill this year on land use on airports.
Does the county commission have the ability to set some bumpers of their own?
Yeah, so the idea is,
State law?
yeah.
Non-conforming?
Yeah, when it comes to nonconforming rights, state law defines what is a nonconforming right, but and basically says that it has the right to continue. And state law says that if, for instance, if something's involuntarily demolished, like by a fire or something that wasn't the fault of the property owner, the county can't prohibit it being reconstructed. But other than that, I mean, state law says that counties can set the terms of how long you can have a nonconforming right, because that's something that's not really utilized a lot. Is state law technically does allow you to phase out a nonconforming right. It's called amortization. It just means that you at least have to allow that right to continue long enough that the property owner recoups their investment in the property. But that gets a hairball in its own. Like, how do you figure that out?
Yeah,
If you want an example, call Provo City, because they've done it. Especially particularly with Provo City, they've litigated this question a couple of times because they're a college town and they've got a lot of basement rentals and student apartments that they've tried to really have a handle over, and so they've changed the law about when you can have a basement apartment, those kind of things, and those have resulted in all sorts of disputes about nonconforming rights.
Ancillary dwellings and
Yep.
I have a question kind of in reverse. So say a developer, landowner,
Mhm.
their project is approved, they go through the process and the ordinances spell out for a road.
Mhm.
And so they build the road to the standards, solid surface, width, everything. They do their part, they fulfill their part of the ordinance. But then the county doesn't come in because we required that of them.
Yep.
But then the county doesn't want to adopt the road to make it a county road for maintenance. But they've given, that's our biggest gray area, planning and zoning, is the roads.
Yeah.
Is the county's burden on maintenance, private roads, access for EMS, those services. That's the bigger, it's just
Right.
kind of a cluster of what we can require, what is required of us.
Yeah, and so that kind of speaks a little bit to the nature of differences between cities and counties, right? Cities, the whole idea that you incorporate a city and create a city is to provide public services, right? To provide, sewage, water, electricity, and, roads and those kinds of things. But if someone wants to develop out an unincorporated county area, we let them do it, but it's more of a, you're doing it on your own kind of thing. You bring your own services, we'll let you develop. That's kind of the simplified version of, county development. And so sometimes, county ordinances may not require you to dedicate a road. They say, if you want, you need a road so we can have, emergency access, but you keep the road, right? We don't want to maintain it. I mean, that's fine. I mean, asking the property owner to, well, if it's a private road, I mean, I'm just, thinking of whether that's an exaction. If it was a public road and they're asking them to contribute to it, then that would be an exaction. But if you're just saying you can build your property as long as you provide a road, that's just a valid restriction. Keeping in mind, though, that, the one thing that is another tricky aspect of roads is that in Utah, the two ways that roads could be created is one through dedication, right, through, platting roads, right, when property is divided. But the public can also create a road by its use. We call it roads by use, right? And so state statute says that if the public generally uses a road as a public thoroughfare, meaning it gets from point A to point B of some sort of public interest, and they do that continuously for 10 years, and the property owner doesn't do anything to interrupt that use within the 10 years, then the property owners are basically abandoning that road to the public, in which case the county takes it over. It's now a county road.
And it's no choice, because that's what we have now is the county will maybe entertain that ask from developers. So a lot of developers come in, they want in and out.
Mm-hmm.
It's like they don't want to be responsible for maintaining roads and that. And so the way that we've kind of played it out is if the developers build it to county standards, then they can ask the county whether or not we'll take on that road as a county road, and then the county maintain it from thereafter.
Yeah.
But it's an ask that the developers have to make. But if they, that's exactly, that's what I just heard too. So, but that's part of it is like, well, if the county doesn't have the staff or equipment to maintain all of these, I mean, San Juan County is a pretty big county, and so that's a lot of roads. And so if the county chooses not to accept that road, then we don't. I mean, we tell the developers, even if you brought it up to that standard, some of the developers will come back and say, well, I constructed it to the county standard, and the county staff was like, well, we were not there. We didn't see the lifts. We don't know how much asphalt you have on there, compaction, things like that. But kind of essentially you're saying if the public's using it for 10 years, it is that no matter what.
Yeah. So I'll give
that's
some.
kind of scary. But
I'll give a number of unsatisfying answers for everyone.
well, he's back there is like, sweet.
Yeah.
Because
So
we want in all cases, in all scenarios, we want the developers that are coming and developing their properties to develop and establish the road systems in a maintainable fashion.
Okay, so here's all the caveats, right? So yes, the public's use does create a public road if it's a thoroughfare. So there's some instances where if you're at the end of the road, if it's a development that's where the road dead ends, and the only people using that portion of the road are those immediate property owners, then, immediate property owners aren't really considered the public in general, right? I think it would have to be the general public are using the road as getting from point A to point B. So it's kind of traversing, right? So that's one possibility that might not be a public road, but the other aspect of it is, there's, depending on how the road's built, this might be the interesting aspect is if it is built to county standards, because, there's classes of roads, right? And there's certain, the statute spells out that the county maintains roads, but, you can have a dirt road, right? That doesn't really need a lot of maintenance, but yeah, if the road is built in a way that it's now classified when it does become the county's road as a class C or something else, right? Then maybe there's a little more direction that the county needs to maintain it. But the other unsatisfying answer I'll give is that state statute, all it says is that counties have to maintain their roads, but doesn't say anything else. So it doesn't say that here's what it means to maintain it, how often. It's up to the county to basically determine how they maintain roads. There's not really any cause of action to sue the county to say you didn't maintain this road, right?
Like we were out there once a year.
Yeah,
every 5 years.
And then the other aspect of this is, yes, the public can create a road, but there's not really anything stopping the county from turning around and vacating any. I mean, the county can vacate any road it wants. They do have to, make a finding that it's not going to cause any detrimental impact to property owners in doing so, but the county can vacate a road if they want. So it's kind of this back and forth of, the public might create a road, but if the county really doesn't want it, they could technically get rid of it.
Okay.
But with that, so just take Spanish Valley, which is the most northern part of San Juan County. In our ordinance in Spanish Valley, which is separate from the rest of San Juan County, it states that you have, any new subdivision has to have a 3-inch hard surface.
Mm-hmm.
So as planning and zoning, as we make a recommendation to the commissioners, we're requiring that in any new subdivision. How can we require that if there's a chance the county may not adopt?
Well,
Now it could be a private road, so if it's a private road, if the county decides not to adopt it, now it's a private road, so how do we have the authority as a planning and zoning commission to require that?
I mean, I think the short answer is, as far as what counts as a valid restriction on property or valid land use regulation, again, remember that standard is it's just reasonably debatable to advance some general welfare or health and safety. So the county can set standards for private roads, right? If you want to build residential development, you have to meet these certain road standards, right? They don't have to accept the roads. I mean, they can say that they're private roads, right? But I think that it would be probably ill-advised for the county to say these roads are all going to be private if it's very clear that they're going to end up as public roads, right? I mean, I think it makes sense to say, this is a private road if it's just an interior subdivision street that's not really a thoroughfare. But if it's the main road through the subdivision that continues on to other, I think that it's hairy to say that we're not going to accept that road. I think you need to accept the road because it's,
What about?
because the inverse of that is if it's a private road, the private community could technically gate it off, right? And then that's not going to make the fire department happy. So that's why, when we often deal with where the city or county are not wanting communities to gate off their private roads because they still want EMS access, right? And I said, well, if you want to take out our gate, you got to pay for it. You got to either take the road or you got to pay us for the access. So
I think the final one for me is water. So you've got, and we will experience this, especially to the north of us, is lack of water. So lack of water, does that dictate development if you have land use and you have zoning and zoning allows for something and then all of a sudden they go, well, there's not enough water, and is there a consideration of water and amounts in land use ordinance where it's not there? And can it be there prescriptive as, you have to, for a half acre, you've got to, have this much water, 1 acre foot of water or whatever.
Yeah. So there's different ways that water is kind of addressed in land use. Kind of initially is, I briefly mentioned one of the big differences between incorporated cities and unincorporated county is cities exist to provide services. Mm-hmm. And so it's presumed that, if you incorporate a city, they're going to provide you water, right? That's not really the guarantee in county development. It's more of you bring your own services and you can build. So it sounds like, I think there was a comment that it's kind of an open aquifer. So there's not really currently a requirement for water, but you could, right? So, I mean, if the idea is that, because there's a lot of instances where you have what we call adequate public facilities ordinance, where basically the idea, we don't do this a lot in Utah, but other states do this, where you make it a requirement of the development process that the person prove that there are adequate facilities to accommodate their development. In other words, if it's more of a time and sequence problem, it's the pioneering problem. If there's not really any way to service the development, then probably not a good time to allow development to happen, right? Unless they can show that, they've got water, they've got all these things. And so, with like annexation, a lot of times it's, they turn in water shares to then get city water, right? So you can, have something like that. But that gets to another point of, if you have a rule that requires a property owner to give you water shares or water rights, right, or some sort of water, then that triggers exactions, right? So you have to make sure that it's proportionate to their impact. And in fact, the state code on exactions specifically kind of mentions water rights specifically, and there actually is a bill to kind of further hone that in. But if I recall right, that bill this session is actually only changing those water exaction requirements for municipalities and not for counties.
Okay.
But yeah, great question. So the answer is yes, you can set standards to make sure that people have water before they develop. If they don't, right, the other two hot topics that we've kind of had recently is moratoria. And so that's the idea that the county council, so there's a provision in LUDMA that says that, because we've talked about the legislative process to this point, is it starts with the planning commission, then comes to the county council. There's a provision in LUDMA that says that the county council can pass a temporary land use regulation without the recommendation of the planning commission as kind of an emergency provision. In other words, if there's some compelling countervailing public interest that needs to be addressed right now, the county can pass a temporary ordinance that lasts for 6 months. And that's kind of meant to allow you to get your ducks in a row to figure out if it's an infrastructure problem. We've heard it come up with a community passing a building moratoria, prohibiting any processing of applications or development because there was concerns with their water tower infrastructure, whether it was falling apart, So they're basically, it's putting a hold on all applications for 6 months so that you can either fix your ordinances in a certain way or, address some other compelling need. And then the other ripcord provision that is kind of rarely discussed is, we've talked about if an application complies with zoning code, then it's entitled to approval. You have to approve it. But there's one exception, there's kind of a but if. And one of those but ifs is if there is a compelling countervailing public interest, that's the language, that there's some compelling countervailing public interest that'd be jeopardized in approving the application. In other words, that's kind of the last resort if, the county is not required to approve an application that's going to, harm the community in some way. The compelling countervailing public interest, we would say, is a high standard. You have to make specific findings about what is that reasoning. It's not just any reason, we don't like this, so we're not going to approve it. You have to say, this development will harm the community in some way. And a lot of it has to do if there's not available water. That's where we've seen this come up. So there's always a ripcord in the end. So.
But is there a difference in, say, Scott requires somebody to prove their water right. They get their water right in Utah. Just because they've got a water right doesn't mean the water's available. So, that's my question. Is it a different way that a county would look at it?
Well,
You've got a well. You've bought water. There's no water. Potentially right.
Yeah. Right.
The county look at that. We look at the state tells us, they've got a water right, and that's what we required is that they had water and the ability for either seed or second.
Yeah, so those are kind of the circumstances where I think a moratorium or those kind of things come in as, people have paper water rights, but if the reality is there's just no water, then, right. I mean, ideally, the county should be on top of things as far as, or I guess the better example is like cities. Cities have to provide water, so they have to anticipate how much water they're going to provide. So if they have a land use code that allows all sorts of development and there's all this development eligible property within their jurisdiction that they know of, they need to be on top of acquiring new water rights that they're going to need for that development. It'd be kind of negligent of them to just allow open development in their code in a way that they're not prepared to accommodate water-wise, right? But nevertheless, that's happened in a couple instances, right? And so the developers are up in arms because they say, well, the city should have known better. They needed to plan for this, but at the same time, that's we're not going to require the city or the county to approve development if it's going to harm existing water users, right? That's kind of what it comes down to. Is you'd have to basically prove that that would be the case, that there is no water, right? So.
Any other questions?
Okay, anybody else? Rick, we really appreciate you coming down and giving us this land use 101.
Yeah,
I think it'll help us make better decisions. I don't think we've made a bad decision on land use, but if we have, this will help us.
Yeah, I was gonna say I don't think we've got anything in our office, right, dealing with San Juan County. So keep it up. But again, a lot of what we do is just answer questions. So anyone's welcome to call us with a question they have, and we're happy to help out in any way we can.
Awesome.
Well, thank you very much
Appreciate that.
for coming. This will be we'll close our work meeting now, and we'll take a 2-minute break. Then we'll start our commission meeting. So we'll welcome all of you here for a commission meeting, but
so much.
we'll start in about 2 minutes.
You helped me a lot. Thank you.
Thanks, Rick. That was awesome.
Hey, Mac.
Yeah.